So thank you for joining us. I'm Zach Rothenberg. I'm here with my partners, Mark Hardiman and John Mills from Nelson Hardiman. We are 20 lawyers here in Westwood practicing healthcare law. We are largely big firm refugees who left that life to sort of start our own path here at Nelson Hardiman. Our practice generally breaks down into three groups. Just to give you a quick rundown of who we are, we have a regulatory practice that's led by our founder, Harry Nelson, that does compliance work, focusing on licensing, operations, changes in ownership, etc. A corporate and transactional practice that's run by our partner, Rob Fuller, who comes both from the big firm world and has also spent, I think, something close to a decade running a hospital on his own. That practice does acquisitions and sales, investment and financing, sort of your traditional corporate transactional group. And Mark, John, and I run the litigation practice here at Nelson Hardiman. And our practice generally focuses on three things as well: commercial and government reimbursement disputes, general business litigation that happens in any other industry, happens in healthcare as well, as we all know. And then finally, fraud and abuse and whistleblower actions and related investigations, which of course we'll be focusing on today. If you ask me, I'd say what sets us apart from most other firms is that we come from the big firm world. We have that experience and sophistication, but with the small firms, hands-on approach, nimbleness, tenacity, and eagerness to please. So that's us. I will leave it at that for now. John and Mark, feel free to chime in when you feel like it to tell us about yourselves. And I will, from there, turn it over to Mark.
Yeah, thanks for that, Zach. My name is Mark Hardiman. I'm a former federal prosecutor, and since 1999. Prior to Nelson Hardiman, I was at Hooper Lundy, but since 1999, my entire practice has focused in on fraud and abuse issues, both in hospital systems all the way down to individual providers. I'm not sure I know anyone on this call, but when I was at my last firm, Hooper, I actually did a fair amount of fraud and abuse compliance work with Prospect. Working with, I think, the former GC primarily. So I'm sort of familiar generally with how the Prospect system operates and the like. John?
Yeah, thank you, Mark and Zach. Yeah, my name is John Mills. I've been practicing healthcare pretty much my entire legal career. I started off at Hooper Lundy as well. That's how I got to know Mark, actually. I joined Hooper in 2005 and was there until 2011. And then I moved over to my current firm, Nelson Hardiman. And my practice actually is a big part of my practice is dealing with commercial insurance claims, both pursuing payments from insurance companies, but also a big part of my practice has become defending against overpayments, recoupments, and more, as we'll be talking about during our presentation, defending against fraud lawsuits being brought by commercial insurance plans.
So jumping right in, the subject of today's webinar is really what hospital systems should be doing with commercial claims in light, especially in California, of the existence of the California Insurance Fraud Prevention Act, and how hospitals need to incorporate the existence of that particular statute in terms of avoiding additional sort of false claims like risks with respect to their commercial plans. We'll be discussing how historically most hospital systems have primarily, if not exclusively, focused their compliance efforts on avoiding what I call federal false claims, or in those states, including California, that have basically duplicate false claims statutes that mirror the federal one with respect to state programs, avoiding false claims liability based on submitting plans to government programs and why that is. And then we'll discuss why the IFPA, the Insurance Fraud Prevention Act, in what the interplay is with that statute and the federal false claims action. Basically, this is a result of a trend we're seeing where false claims actions, to the extent that the basis for the false claims action involves errors in claims that are likely to be replicated in the commercial plan claims that the system is submitting, that we are seeing more and more that there is almost always an IFPA claim added to what used to be the sort of traditional federal or California false claims in the qui tam lawsuit. So we'll be discussing that. We'll be discussing, without getting too much into the weeds, the specific provisions that are similar to, but certainly not identical to the false claim statutes in terms of how it operates and what penalties there are. And then we'll be finishing up with our recommendations in terms of the best IFPA defenses that we view as available, and more importantly, on the operational nuts and bolts, what we would recommend in terms of tweaking existing compliance programs in terms of their best practices to avoid the pitfalls that you can get yourself into if you ignore the potential liability under the IFPA with respect to the system's commercial claims. So not too surprisingly, historically, most hospital systems compliance plans focus, if not exclusively, as I mentioned before, primarily on compliance with federal and state program requirements. The reasons for that are fairly obvious. Historically, there's been active enforcement on both the federal and state side with respect to recovering money from healthcare providers. And the reason providers pay attention to that is obviously there are substantial penalties associated with submitting false claims to government programs, including treble damages and per claim penalties ranging from $11,000 to $22,000 per claim. And as a matter of reality, it's very difficult to actually litigate against the federal or state government when they bring such a false claims action. So most systems spend a fair amount of time and effort ensuring that they do not become the target of false claims action, be it by a whistleblower or brought directly by the government. Another reason why compliance plans tend to focus on government programs is both Medicare and Medicaid have a 60-day overpayment rule that basically says that if you discover an error, just a simple error, and fail to identify and return the overpayment during the next 60 days, that can turn that overpayment that was otherwise the result of a clerical error into an actual false claim, which is known as a reverse false claim, and is specifically provided for as a cause of action under both the federal and California versions of the false claim statute. There's also a specific requirement and model compliance plans that are put out by CMS that make it clear, to the extent a system didn't realize it, that there's an expectation that systems have robust compliance plans. And as a result, most compliance plans tend to follow the recommended structure and the various components of the plan that have been recommended by CMS. And that model, unsurprisingly, doesn't say anything about what you're supposed to be doing with commercial plans. And then finally, of course, unlike commercial plans that at best could try to exclude a particular hospital or system as a contracted provider, they can't generally prevent you from providing services, especially emergency services, out of network, as contrasted to CMS having the authority, the death penalty authority, to actually exclude a hospital system or a particular hospital in that hospital from the Medicare program. And California has a similar authority to exclude a hospital. So that lurks in the background as another reason why hospitals, unsurprisingly, primarily focus on compliance with federal and state program requirements with respect to their compliance plans. Another main reason that healthcare systems focus in on the FCA is because of the reality that healthcare false claims acts are a robust source of revenue for both the federal government and, to a lesser degree, the state government. In 2019, DOJ recovered $3 billion in federal FCA and civil fraud recovery from all sources, but $2.6 billion of that, 90%, was recovered from Medicare healthcare providers. This really, if you go back to the early 90s, it was false claims actions were primarily being brought against defense contractors for, the $475 hammer that was being charged the Army, or the 4,500 toilet seat cover that was being charged the Air Force. In 1996, I think it was Attorney General Janet Reno made both violent crime and healthcare fraud a priority, and that really was the beginning of the shift in the world of both the whistleblower lawyers and the government, in terms of really starting to recover very significant sums of money based on false claims theories of recovery. As you can see here, in 2019, 2.1 billion, or basically the majority of the healthcare recoveries, were as a result of whistleblower actions. That is, private citizens that brought the lawsuits on behalf of the government, which is one of the potent weapons that are included in both the federal and state false claims actions, that allow insiders to bring it on behalf of the government, and then the government decides whether it's a good case to take over, or if they decide not to take it over. We're seeing more and more cases where the whistleblower will decide to prosecute the case against the defendants anyway. And in terms of management of your personnel, the reality is that at least in 2018, 63% of whistleblowers were current or former employees. And generally speaking, the primary candidate for a whistleblower is an employee. That hasn't actually, by the way, changed that much in 2020. Even in 2020, the COVID year, DOJ still managed to recover $2.2 billion in false claims recovery, of which 1.8 billion was healthcare. So basically, the same proportion, although the recoveries, not too surprisingly, were somewhat lower, but still significant given the fact that everyone was working remotely. This table here just shows you how healthcare has really taken over historically as the primary percentage of false claims recoveries from all sources. If you look at the bottom there, it begins in 1987 and then moves through 2018, and orange is the proportion of total qui tam recoveries that are healthcare. So there was basically a minuscule amount in 1987, and then since then the percentage of the share of recovery that is healthcare has largely and consistently increased to where we are now, where it's basically the vast majority of recoveries. The next table shows a similar, although not as a dramatic trend, but if you look at the bottom there, orange is the proportion of qui tam cases that are brought by whistleblowers rather than directly by the government. In other words, there are cases where the government just files false claims action without any private citizenry involvement. And you can see that that was more the case in the late 80s and early 90s. But by 1993 and through to date, the vast majority of recoveries under the false claims statute are initiated by private whistleblowers on behalf of the government. And this final pie chart illustrates what I said before in terms of what type of whistleblower or relator, which is another word for whistleblower, account for the majority of citizens who bring false claims acts on behalf of the government. And you can see here that, if you combine former employee 49% with current employee 14%, the majority are in fact brought by employees. And obviously that's an important thing to remember as an HR matter in terms of how you are dealing with your employees, especially the ones that you are terminating, which would be the subject of an entirely separate webinar about some of the pitfalls you can avoid in terms of either identifying the former employees that are leaving as a potential whistleblower, or minimizing the chances that they are a whistleblower or decide to become a whistleblower when you're terminating them for a completely unrelated reason.
Okay, I'm gonna now switch gears a little bit and talk about the IFPA. As you can see from Mark's slides, all of this activity and focus on the Federal False Claims Act in cases being brought by government healthcare programs has meant that overall in the healthcare industry, hospitals and other providers generally focused for good reason on federal claims and the associated risk of payment under those programs. In our experience, though, hospitals have put in a lot less effort in paying attention to false claims associated with commercial plans. And we think there's a perception that the risk with commercial claims carries less severe consequences. We'll talk about why that's really not accurate, but that perception comes from probably the fact that most providers' experience with commercial plans is that they notoriously underpay claims. So it is, generally speaking, it's the providers going on the offense against the payers in the commercial context. I know in my own practice, it's that was usually the phone call I would get, and it's been more recently that I'm getting the phone calls about the plans going after them. Historically, if a private plan was going to raise fraud, it's usually in defense to a lawsuit being brought against them for underpayment. So, in other words, because historically we have not seen large lawsuits being brought against hospitals relating to commercial claims, hospital compliance programs have tended to minimize commercial plan billing. And we think the underinvestment in commercial claims related to compliance is probably a serious mistake. Next slide. So hospitals and other providers in California are overlooking an important law that is actually being increasingly utilized by the plaintiffs' bar. And this is the Insurance Fraud Prevention Act, the IFPA. And it's a whistleblower false claim statute that applies to claims for benefits and services under a contract of insurance or submitted under the California workers' compensation statutes. When the IFPA was originally enacted in, I think it was in 1993, it was really just meant to address workers' comp fraud. The express purpose at the time was at the time of enactment was to deter fraud associated with automobile accidents that were taking place on the job. But later amendments expanded its scope dramatically, and one of the areas that it's been expanded into is healthcare fraud. And as with other false claim statutes, we have seen this law used more and more to go after healthcare providers. The IFP actually comprises an entire chapter in the insurance code, and obviously we don't have time to talk about all of its details. The specific provision I want to draw people's attention to is Insurance Code Section 1871.7. Under this provision, there are two general methods for establishing IFPA liability. Subsection A prohibits employing persons to steer and procure patients. That's paraphrasing it, but that's essentially what it says. And the statute uses somewhat archaic language when it refers to steering and runners and cappers. But the general idea is that the claim is tainted in some measure by an improper referral. So much like the FCA, the IFPA prohibits, this is an anti-kickback law, is essentially what it is, and a false claim that is obtained, a claim, an insurance claim that is obtained through improper referrals is a form of a false claim under the IFPA. The statute uses the word employ, which is significant because cases have actually relied on this as a requirement for liability. But they have not necessarily explored the contours of what precisely constitutes employment. So arguably, employment for purposes of the IFPA is the same as employment under the California Supreme Court's test for employment, which is a pretty strict test. On the other hand, there is some recent case law that has interpreted the term employment pretty broadly under the IFPA. In fact, in one case, a doctor was paying rent to another doctor, and the allegation was that a portion of the rent payment was a disguised kickback. The court found this payment was sufficient evidence to constitute employment under the IFPA. Then subsection B of section 1871.7 states that any claim that violates section 550 of the penal code is a violation of the IFPA. So penal code section 550 contains more than 11 different types of fraud, some of which specifically address healthcare services. Subsection B also calls out violations of penal code section 549, which is the solicitation of business knowing that the other party intends to violate 550. It's really a way of bringing in conspiracies. And I want to mention real quick that while we are focusing today on California's IFPA, it's a safe bet that most states have analogous statutes that would apply to claims being submitted to commercial carriers that are based out of California, that are outside of California, that are issuing policies outside of California. So this presentation, while it's focused on the California's statute, it does have some applicability to non-California insurance claims. So section 550 of the penal code, it lists maybe a dozen areas of conduct that constitute false insurance claims. And the ones that are applicable to health insurance are the following: knowingly presenting a false or fraudulent claim for payment of loss or injury under a contract of insurance. So this is pretty straightforward. If you submit a claim for payment under a health insurance policy that you know contains false information, that's a crime and it's a violation of the IFPA. Another one is knowingly presenting multiple claims for the same healthcare benefit. So that would be essentially double billing, intentionally trying to get paid multiple times for the same services. Another one is knowingly presenting a claim for payment of healthcare benefits not used by or on behalf of the claimant. An example here would be submitting a claim on behalf of a provider who didn't actually provide the service, or maybe another provider is actually the one that rendered the service, or billing under a policy someone who didn't receive the service, just getting it under the wrong insurance policy. And then another one is knowingly making any written or oral statement in support of a claim for payment when you know the statement contains false information, or even if you know the claim for payment is false. This one is interesting because it is one of the provisions used by car insurance companies to go after providers, doctors, for what they believe are false medical reports in support of a personal injury claim. But this provision can be read pretty broadly. And in fact, it could be used to even go after a lawyer who submits an appeal of a denied claim when the lawyer knows the claim is false and the lawyer and knows that the lawyer's client is not entitled to the insurance benefit. There's another type of conduct that is listed in Section 550 that I will discuss in the next slide. But before I get there, it's worth spending a minute on the meaning of false claim under Penal Code Section 550. So like with the Federal False Claim Act, there is no definition of what constitutes a false or fraudulent claim. The courts have grappled with it, of course, and they have come up with a broad meaning of falsity. Essentially, a false claim is any claim that is in some manner deceitful or conduct that is done with an intention to gain unfair disadvantage over the payer. Case law makes clear that a claim need not be paid for liability to attach. This is true, of course, of the FCA as well. But this is important to remember because it is a common misconception for providers to believe that there's somehow a built-in no harm, no foul defense if the insurance company denies the claim. It doesn't pay out any benefits. That's simply not the case. It's the presentation of the false claim that is the punishable offense. Next slide, please. So I want to spend a minute here on one of the more interesting subsections of Section 550 of the Penal Code. This one we think is one that's going to start gaining more attention. It states, this is Section 550b3. It states, it is unlawful to conceal or knowingly fail to disclose the occurrence of an event that affects any person's initial or continued right or entitlement to any insurance benefit or payment, or the amount of any benefit or payment to which the person is entitled. This provision is being interpreted to impose an affirmative duty on providers to disclose an overpayment. In other words, it's being treated like Medicare's 60-day rule. So if a provider discovers that it received an insurance payment in error and nonetheless fails to disclose that to the insurance company, then the failure to do so could lead to liability under Section 550 and the IFPA. Unlike with the FCA, though, there is no specific requirement on when to report or to disclose the overpayment. It doesn't impose a 60-day deadline or any deadline at all. In our view, any disclosure should be reported within a reasonable amount of time upon discovery of the overpayment in the context of the facts, of course. But it's tricky because under the plain language of the statute, the violation occurs immediately upon an act of concealment or failure to disclose. So a whistleblower or a prosecutor can argue that a couple of weeks is unreasonable and was intentional. And by the way, there also is a California Court of Appeal decision from this year, 2021, in which a provider was prosecuted criminally under Section 550b3 for making kickback payments. And the theory there was that the payment of kickbacks was an event concealed from the insurance company, which if the insurance company had known of the kickback payments, then it would not have paid out on the claims. So it's kind of an interesting backdoor kickback theory. And in that particular case, it wasn't an IFPA case. It was just a straight criminal prosecution. So kind of interesting that they relied on that subsection 550b3 of the Penal Code to prosecute a kickback theory. But at any rate, I thought it was interesting. I'll turn it over to Zach, please.
Great, thanks, John. So the procedures under the IFPA are generally similar to, but not identical to the False Claims Act. An IFPA action can be filed by one of three groups of plaintiffs. The first is the California District Attorneys, then the Department of Insurance. But in that event, the Department of Insurance sort of has to give the district attorney first dibs. They have to run it past the DA to have the first crack at it. But then the Department of Insurance, or alternatively, any, quote, interested person. Interestingly, the statute specifically calls out insurance companies as potential whistleblowers in essentially false claims actions for claims that they've had to pay. So the insurance company that has suffered the loss can, I guess, as an alternative to an overpayment demand, instead file an IFPA whistleblower action. The mechanics are similar to the False Claims Act, where it's at least where it's an interested person as opposed to the government filing the action. It is filed under seal. The district attorney or CDI then has at least 60 days to investigate. The whistleblower is required to send all material evidence or information to the DA or CDI so that they can decide whether to intervene. And at some point, once they have finished that investigation, they are required to pull the trigger and decide whether to intervene or to decline intervention. If there is no intervention, the relator proceeds with the case on his or her own. And then where there is intervention, typically the government will control the case, the litigation of the case. I had an interesting experience last year in which a case where the government did not intervene still followed along. And when the plaintiff eventually decided to dismiss her case, she filed a dismissal. Everyone sort of thought the case was over. And the government said, hey, we never got to sign off on that dismissal. And the dismissal was ultimately undone. The case was sent back to the trial court for further litigation. So interestingly, even though the government decides not to intervene, it still must sign off on any settlement or dismissal that the relator makes. And then going back to the complaint, it's filed under seal. There's the decision on intervention, and then at that point, there's a court order, and the complaint is unsealed and served, and we're off to the races. In terms of IFPA remedies, again, it closely tracks the False Claims Act. There are up to treble damages in the amount of each false claim or fraudulent claim, civil penalties like in the FCA of between $5,000 and $10,000 for each fraudulent or false claim. There is the opportunity for equitable relief, typically in the form of restitution, as is necessary to bring the plaintiff back to the position they were in prior to the misconduct. And of course, that's a difference from the FCA, because here you often have a private party, the insurance company, for example, initiating the lawsuit. And so part of the relief there is to restore the insurance company to the position it was in before the false claims. In other words, returning the false claims as restitution. Then, of course, attorney's fees and costs and injunctive relief is always an option in terms of future activity. So like with the False Claims Act, the monetary remedies can add up quite quickly as they're based on individual claims. There can be a significant hindrance on future activity in the form of injunctive relief. And then there's always the threat of criminal prosecution. And that is also something that is specifically called out in the statute, that the relief is remedial rather than punitive, so that the punitive element of it is still on the table in terms of criminal prosecution. And then, like we said before, the IFPA, like the FCA, is a bounty statute that is intended to incentivize people with evidence of fraud and abuse to come forward. When the government intervenes, the share for the relator can be between 30 and 40%, depending on the contributions of the relator. In non-intervened cases, because the relator is doing the lion's share of the litigating, that share is higher, 40 to 50%. I just wanted to point out that typically from the defendant's perspective, this is one of the key moments in the litigation, and they're usually not even aware it's happening in terms of whether the government decides to intervene or not. Of course, the government, in intervening in the case, brings a lot of validation to the claims. I think to the judge, I think there's a sense that the government knows what it's doing and vets these cases with sophistication and experience, and would only intervene in cases that have legs. And I think to a jury as well, when the government is in the prosecution, in the plaintiff's chair, there is a sense that this is truly on behalf of the people. Whereas when you have a private whistleblower, I think it is more difficult to make the point that the plaintiff, who is an interested party particularly, is acting on behalf of the people of the state of California. And so cases often tend to fizzle out when there is no intervention. So in terms of which kinds of cases are brought against hospitals and hospital commercial claims in particular, the IFPA covers a lot of ground, and typically, at least in the hospital's eyes, the focus is on kickbacks and other kinds of patient steering. Any claims that may have been tainted by an improper referral, unnecessary or unperformed services in the sense of medically unnecessary services, medically unnecessary admissions, upcoding and exaggerating the services that were provided or that were needed, and then of course, like John mentioned, retaining known overpayments. And I think that one can be a particularly hard pill for folks to swallow for the reasons John touched on. I think there's a sense that if there's an overpayment, the insurance company is going to find it. That's sort of their job to find those. They're financially invested in that hunt. And then I think there's also a sense of, well, you know, the insurance company is squeezing us so tightly that if by chance we happen to make a few extra bucks on an overpayment, you know what, that's just sort of leveling the playing field. And while I understand those sentiments, I think they get folks into trouble, and that the idea of retaining these overpayments is a real thing, and something that requires focus and paying attention to. So just quickly, I wanted to cover three of the sort of better known and larger IFPA cases and settlements over the past few years. The first one, and maybe the most notorious of the bunch, was against Sutter Health. There was an allegation that the hospital was using an anesthesia code to charge as a time-based code for services that had already been captured as part of a global charge. And I think they actually were charging 3 times, was the allegation, for the same service. And Sutter maintained that it was really just doing what every hospital system was doing and just kind of following suit. But it ultimately still settled just weeks before trial for $46 million, having spent millions of dollars in attorney's fees. And the settlement also required some real systemic changes in how Sutter was billing for anesthesiology services. And that eventually led to really a change industry-wide in how anesthesia charges are served, are billed. And interestingly, I thought this was unusual and surprised me. I didn't realize this was an option. It turns out that this CDI it did intervene, but only after the relator had survived a demurrer and a motion to compel arbitration. So it sort of sat in the background until the plaintiff had really proved that they had a good case, and then the government decided to intervene. Second is the Warner Chilcott matter. That's a pharma company where 3 former employees claimed that the company was using illegal inducements to influence doctor decisions to prescribe medications, and that they were also falsifying authorization forms to increase coverage for prescriptions. And this $23 million settlement was actually part of a $125 million global settlement that also involved anti-kickback statute claims and claims under HIPAA. And finally, the Bristol Myers matter, involved sales reps who were paying kickbacks to induce physicians to increase prescriptions for certain drugs. And that litigation lasted nearly a decade. And after all that legal expense, Bristol Myers still coughed up $30 million as part of the settlement. So these can be huge, huge cases. And then there's others that I won't bore you with. John?
Yeah, so let's talk just a minute or two about some of the important differences between the IFPA and the FCA statutes, because we don't want to give the impression that it's a mirror image of each other. One major difference is that the government is not overtly damaged by an IFPA violation. That's, I think, stating the obvious. With the FCA, you have the federal government enforcement mechanism vindicating harm that's being suffered by the government. In other words, the government is the one being deceived by the false claims. With the IFPA, in contrast, you have a state enforcement regime where the harm is being suffered by a private insurance company, not the state. The state, of course, is going to argue, well, the fraud affects all of us by driving up premiums, and that may or may not be true. Premiums seem to go up anyhow, regardless of the statute. But that's we think that's a key difference in terms of how you think about these two statutes, because of that reason, the IFPA actually can have a much wider net to capture more types of potential fraud. Another interesting difference is that the recovery under the IFPA is not limited to claims paid to a single insurance company. So even where the insurance company is the whistleblower, the lawsuit can extend the scheme that's being prosecuted to claims presented to other insurance companies. In other words, whistleblower insurance company A uncovers a fraud scheme, proves that the scheme extended not just to insurance company A, but also insurance companies B and C, and can collect penalties and damages for claims made to those insurance companies as well. That's of course not an issue with Medicare, since there is only one payer. And as a result, the scope of discovery in an IFPA case can actually be much broader and much more burdensome for the defendant than in a FCA case. And just to kind of put a finer point on that, think about the overpayment example. If you discover you've got some problem with how commercial claims are being paid, or some sort of error, some billing error or something, and you find, and let's say one payer brings it to your attention, and you say, oh yeah, okay, fine, we messed up, we'll pay that back. But then you don't pay it back to, the same error exists for all the other payers out there, and you didn't pay it back to them. That could be the basis for an IFPA action. And you'd only need to have one payer go after you for it, but it could potentially extend to all the other payers. So that's how broad the IFPA can be used by a plaintiff. And then perhaps the most important difference, and this is one that Zach will get into in more detail and his next slide. But depending on the theory being pursued under the IFPA, there are different intent standards than with the FCA. The FCA has a reckless disregard / deliberate indifference standard for intent, whereas to prove a Section 550 violation, because it's under the penal code, there must be criminal intent to defraud. So a higher standard, of course, for a plaintiff to prove. So, but Zach will talk more about the intent standards. Back to you, Zach.
Great, thanks, John. So we're kind of winding down here. I want to make sure we leave a few minutes for questions. I want to talk about two defenses that are prevalent and are sort of battle lines, I would say, between the plaintiffs bringing these cases and the folks who are defending them. And the first one really deals with the scope of the IFPA and the kinds of claims it applies to. And whoever it is, can you mute your line, please? So in talking about the kinds of claims, the issue is this, that the IFPA is part of the insurance code. By its own plain language, it applies only to claims that, quote, are pursuant to a contract of insurance and, quote, presented to an insurance company. Now, there's no black letter law on this yet. It's not a settled issue yet, but we've argued successfully in the trial court that this language is to be construed very narrowly, to include only claims made pursuant to insurance policies regulated by the insurance code and the Department of Insurance. So what this means is that it would exclude that claims would not be subject to the IFPA if they relate to managed care plans or healthcare service plans under the Knox-Keene Act, for example, HMOs and certain kinds of PPOs. It would not apply to ERISA plans or out-of-state plans. And this is a huge hole in the IFPA that frankly the plaintiffs bar is not necessarily aware of, and we've had to fight this issue in most of the IFPA cases we've faced, and so far successfully. So it's important to bear in mind that while the IFPA covers a wide spectrum of conduct, it may turn out to be limited in the kinds of plans and the kinds of claims that fall under its gambit. The second substantial defense that we tend to focus on a lot that John mentioned is the intent element, and that it is a higher bar than under the FCA. Claims submissions require a specific criminal intent to defraud. It's a higher bar than the FCA, which only captures, quote, reckless disregard and deliberate indifference. Under the IFPA, there is no liability for mistake, negligence. There's no liability for overpayments that you were not aware of or had no reason to be aware of. So I certainly wouldn't rely on that in formulating your compliance plan, but it's something to keep in the back of your mind in the event these claims are brought against you. And I think we are now on our last slide here. Then Mark, this is back to you.
Yeah, I would say that the other thing, I don't know if it qualifies as a defense, but the reality is that the Department of Insurance attorneys are really a mixed bag. And I've had examples where, putting aside the issue that Zach identified with respect to whether it covers managed healthcare plans, which I wouldn't count on that being resolved in our favor, that is the defense favor. It's currently going to be decided probably pretty soon. It's pending in a court of appeals case that I was involved in. So we'll get an answer on that. But even if they hold, at least as to managed healthcare plans, that it does not apply, I would expect, given the current climate, that there would be legislation that fixes that hole, not with respect to ERISA, because that's a preemption issue, but with respect to the jurisdiction under this particular statute, either being extended to Department of Managed Care Health Plans or some fix that would expand the definition to include those type of plans. But the DCI attorneys are often not very good, and they often just let the case be run by relators attorneys, which can be problematic to say the least. So in terms of defending yourself, you often have, in terms of litigation tactics, substantial room to maneuver, just because the DCI attorneys are not really paying that much attention. And that varies from attorney to attorney. So to finish up, it's our recommendation that hospital compliance programs should equally focus on government programs and commercial plans, to the extent that we're dealing with issues that are likely to be replicated on both sides of the fence, government programs and on commercial plans. So if you're talking like E&M services, certain types of specialty surgeries that you do both on the government side and on the commercial plan side, your compliance plan, if you're auditing that issue on the government side, you should also be auditing that issue on the commercial side. To the extent that there are particular issues that are commercial but not government, you should be looking at those as well. I just had a case recently where it was a sort of weird case where there was an error that was not picked up because it was unique to the commercial side, but ended up being picked up by virtue of the federal side. But there was an IFPA claim, so that was a problem for that particular system. Likewise, we recommend that the compliance program have some mechanism similar to the 60-day overpayment rule under the Medicare Medicaid side, so that when an overpayment is identified on the commercial side, there are processes and policies that the provider, the hospital system, can point to down the road to show that it reacted promptly in terms of identifying the scope of the overpayment and then refunding the identified overpayment back to the plans to avoid the liability under the criminal statute that John identified, Penal Code Section 550B, that is basically the equivalent of the overpayment rule that will turn an otherwise innocent error into a potential criminal violation. And then finally, the regular audits that are done by most systems on government program claims need to be extended at some level to commercial plan claims to avoid problems down the road. In particular, the main problem being the first time the system hears about a problem with their commercial plans is when one of your former employees identifies the error. So that's the worst possible scenario under the IFPA, where the system did nothing and the whistleblower identified an error that if the compliance program had included commercial plans in their annual audit plan, it probably could have been dealt with as a simple overpayment. And with that, I would open it up to questions.
No questions. Well, look, if nobody has any questions, a quick housekeeping matter, which is you should be getting an email from Jennifer Corin in our office with the CLE paperwork. If you're not an attorney and it doesn't apply to you, you can just ignore it. Otherwise, fill it out, and good for you for getting an hour of CLE credit. And then I also wanted to thank everyone. I know you all are very, very busy, and we all really appreciate your spending the last hour with us. And if you do have any questions that pop up along the way, feel free to reach out. Our contact information is right here on the screen. I'm sure you can find us on the internet or through Wes. And we're happy to answer any questions you might have. And with that, yeah.
Actually, Zach, this is Laura LaCourte. I did have a question.
Sure. Yeah.
Is there any movement afoot right now to close the gap that you mentioned, or I think that Mark mentioned? So you've been successful in arguing to carve out Department of Managed Care, but it sounds like that could be fixed in legislation. So is there any movement afoot to do that? And if so, what would that kind of a claim look like in any event?
So,
right, well, I think go
ahead, Zach.
I was just going to answer the first part of the question, which is my sense is everyone's waiting to see how this case in the appellate court is going to come out. And I think if that issue may go away if the appellate court reads the statute to say that there is no hold there. But if the court finds in favor of the defense, I think you probably will very quickly see some movement on the legislative front. Mark, did you have an answer on the second part?
Yeah, no, I was just going to say that I'm not aware of any pending legislation, and it's for the reasons Zach described. I mean, DCI is definitely going to pursue this issue at the Court of Appeals and marshal what I believe are very weak counter arguments to our statutory interpretation and the legislative history that has consistently differentiated between the insurance code and the managed care portion of the code as very separate animals. But to the extent, as Zach said, that there's that the department, that the Court of Appeals agrees with the defense, it will likely be a legislative fix, at least as to the extension of this statute to managed care plans.
Hey, Mark, you know, or Zach, do you know if the DMHC file an amicus brief? Will weigh in on the Court of Appeal, case?
No, I don't think so, and I think the briefing hasn't been completed yet. So if they do, those amicus briefs are normally filed after the briefing by the parties is completed, so that the amicus has the full picture. You had a second part of your question about what the claim would look like, or what the fix. Was that a question about what the fix would look like?
No, I'm sorry, not what the fix would look like, but if there was an extension to cover managed care contracts, I guess I'm just trying to understand a little bit more about what a potential overpayment could look like.
So yeah, so that question is pretty much along the lines of what the false claims liability is going to start to look like under the federal and state programs. As you know, there is a massive shift to managed care under Medicare versus fee for service, and the liability will still extend to the claims that are submitted by the system to the plan, even though it's a Medicare Advantage plan. So while the loss to the government is trickier to figure out, you're still submitting plans and getting paid on those claims. So I don't think at the end of the day that in terms of the system's exposure, it will be that much different in terms of the payments that the bills that you submitted, the payments that you received, and the per claim penalties that would still apply to the claim submission to managed care plans, be it on the federal and state side or on the commercial side.
Thank you.
Did that answer your question?
Yes, thank you.
Sure.